This is an appeal in the matter of Cantor Fitzgerald Co. and Yes Bank Limited.
Yes, Mr. Falk.
Lord, appeal Mr. Jackson for the appellant claimant, Mr. Taylor, Mr. Langley for the respondent defendant.
Yeah.
As you will see, it's an appeal from the order of Mr. Justice Bright, dated the 18th of May of last year. Following a 4-day trial, the judge largely dismissed the claim, and Lord Justice Phillips granted permission to appeal. The claim, as you will have seen, is for a fee said to be due under an engagement letter dated the 17th of December 2019, as amended in February 2020.
Yeah.
At trial, the claim was put on 3 bases. We're simply now concerned with the express term claim. The narrative background, so far as relevant, we submit is within a limited frame and can be taken simply from the judgment.
Mm-hmm.
If you can turn, please, to Core Bundle, tab 9, page 94.
Yeah.
The only relevant bits to pick up, and we submit the only really relevant elements of the background. At paragraph 4, the judge notes that Yes Bank in 2019 was undergoing severe financial problems, which was widely reported and urgently needed additional capital. Cantor was engaged, as were other financial advisors. And paragraph 16, the judge refers to some of the Indian law background, which I shall show you in a minute. Cantor couldn't act as lead manager on certain issuances, but it would be able to assist with any issuance as an offshore advisor, and it was able to offer its expertise and the benefit of its relationships with potential investors, in particular in the US. And finally, in 17, there's a description of the listed investors, as we'll see in the agreement, that the parties typically agree, a list of potential investors who are then ring-fenced for the relevant bank in respect to the financing. That's, as I submit, the only really relevant background we need in approaching the agreement. Mm-hmm. The agreement itself is at tab 17 of the core bundle.
17.
Tab 17, page 169.
Yeah.
And we will, of course, come back to this in some more detail, but just to show you an overview, clause 1 is, in a sense, the most relevant clause for the court because it describes the engagement, and specifically the engagement at the beginning of the clause through a private placement, offering, or other sale of equity instruments in any form, including without limitation, those matters referred to a financing. And there's an engagement to act as the company's financial advisor, placement agent, and arranger in connection with any financing. So that's the most operative clause. Clause 2 sets out the specific tasks which were to be undertaken by Cantor. Clause 3 specifies the agreement to pay, and there was a retainer fee of $500,000 paid in any event, and a transaction fee of 2% of investments at paragraph 3b. The judge noted, and I think it was common ground at the hearing below, that clause 3b is perhaps not as well expressed as it could be, but what it envisages is payment of 2% of investments by the investors, capital I, who are Cantor's investors, as opposed to payment by everybody. Mm-hmm. Clause 6, which I shall also come back to, sets out the duration of the agreement, and in summary, it's a minimum 9-month term agreement because it can't be terminated by Yes Bank within the first 9-month period. It can then be terminated after that 9-month period, but there's then a tail period of a further 9 months within which an investment, if it's undertaken in that period, will still give rise to the trigger for payment. So the trigger, the operative term of the agreement in terms of payment is 18 months, the 9 months of the service, and the 9 months tail fee on top of it, so far as the entitlement to payment is concerned. There's then, if you turn over to page 175, an annex with some additional provisions, which we may come back to and look at some of in due course. 184 is the list of capital I investors who were, if you like, Cantor's investors, ring fence, as the judge described. As at the date of the agreement, there wasn't a list because it hadn't been compiled. that list appeared in the amendment agreement, which is over the page on the next tab, beginning on page 186, and the schedules at 189. And just so that you have it, 189 is a schedule of Cantor's investors ring-fenced for the purpose of the 2% fee. And the relevant investors who invested in what became the further public offer, on the left-hand column, 3 down, is Hinduja Group. About halfway down the left-hand column is Tilden Park. And towards the bottom of the right-hand column is Amansa. So they're the 3 investing investors in the events that happened. So far as the chronology is concerned,
Just before we leave the investors, was the agreement binding when it was made before the amendment, notwithstanding that no investors were identified?
My understanding, it wasn't suggested it wasn't binding. It was, I suppose, to be completed to that extent, but it wasn't, as I recollect, the parties envisaged it would be provided in due course. So it wasn't a case of an agreement which only becomes binding by the time of the amendment.
The lack of identification of the ring-fenced investors wasn't such as to make it too uncertain to be enforceable.
Certainly, nobody thought so at the time, and that wasn't a matter of argument at the trial. I can quite see the point that if it's a 2% fee based on investors, you don't have any investors, there might be an interesting argument there, but it wasn't ever suggested that it was uncertain at the time of the agreement in December and made certain in February. That wasn't
It's your case that it was binding from the moment the agreement was
It was binding in December, and then the relevant people were added in February as expected.
Thank you.
So far as the chronology is concerned, again, not very much to worry about. If you go back to tab 8 of the bundle, page 92, short chronology, gratefully, the agreement and the amendment agreement, December, February 2019, 2020. In March 2020, so just a matter of weeks after the amendment agreement, the Reserve Bank of India imposed a moratorium on Yes Bank, and there was a reconstruction scheme and an additional capitalization of the bank in March 2020. As the judge noted, that changed the financial position of Yes Bank because of the capitalization at that point. And in July 2020, Yes Bank completed a further public offer, raising a substantial amount of money, including investments by those 3 investors which I identified earlier. And that's really as far as the chronology is concerned, and it's the basis on which Cantor seeks payment under the agreement of 2% of the investments made by the 3 investors into the FPO in July 2020. And in short, and this is the point for the court, Cantor says that the FPO was a capital F financing under clause 1 of the agreement during the operative term of the agreement under clause 6, and therefore its fee is accordingly due by reason of the investments alone. Yes Bank says, and the judge agreed with this submission, that the FPO, further public offering, is not a capital F financing because that definition is limited to private forms of financing rather than a public form of financing, which was the FPO, and that's the dispute before the judge and before this court. Can I now show you, I hope also briefly, the Indian regulatory context as the, if you like, the background to some of the issues which we will have to explore. And that's in the supplemental bundle.
Yeah.
Tab 1 is the Indian Companies Act. And the position is, and there wasn't any expert evidence of Indian law as such, so we have to be a little bit careful, but so far as the relevant bits are apparent from the statute, we can use that as we did before the judge. An Indian public company may issue securities to raise finance by one of 3 routes: a public offer, a private placement, and a rights issue. And you can see that if we go to page 28 of the bundle, which is section 23 of the Companies Act. three forms of issue set out in 23. A public offer, and in the explanation at the bottom, it could be an initial public offer or a further public offer, is what we're concerned with. B, a private placement, and 3, a rights issue or in fact bonus issue in addition to that. The public offer, as you can see from 23A, must comply with part 1 of this part of the Act. And there are various rules set out in these subsequent sections about the issue of a prospectus and things to be included in a prospectus on a public offer. In addition, a further public offer must comply with, if you go to tab 2 of the bundle, the Securities and Exchange Board, page 38, issue of capital disclosure requirements, referred to by the judge, ICDR regulations of 2018. And if you then turned to page 65, right, sorry for that, just to show you the starting point, 59 is the section dealing with further public offers, and there are various detailed requirements in the regulations. And at 65, one of the requirements at section 121 is that for a further public offer, the issuer has to appoint one or more merchant bankers which are registered with the board as lead manager to the issue. And it's common ground that Cantor wasn't a merchant banker registered with the board and couldn't be appointed as lead manager on a further public offer. There are also, if you go on to page 66,
Sorry, when it says as lead manager to the issue, what's the context here? I assume some sort of public offer.
yes, sorry, if you go back to 59, what they're talking about in this chapter is a further public offer.
Thank you.
Sorry, to explain that these regulations deal with all the different forms of financing under different chapters. And this first chapter, or chapter 4, I've just taken you to, is a chapter concerned with further public offers.
Thank you.
And therefore, at 121, there must be a registered lead manager, merchant banker, on a further public issue, further public offer.
Presumably there's an equivalent provision for a quit.
I'm going to show you that as well, yes. And at page 66, there are then various more detailed provisions about the disclosure requirements on a further public offer. And you can see in section 122, there are references to a schedule with detailed requirements to be disclosed in the prospectus. And that's referred to in the judgment. And 123, the prospectus has to be filed with the Securities Board within a specified time in advance of the offer. So that's the further public offer. So some of it you see in the section of the statute and some of it in the regulations. If you go back to a private placement at page 28 of the bundle, so we've looked at section 23A, public offer. The second one, section 23B, is a private placement, which must comply with part 2 of the chapter. And part 2 begins on page 36. Section 42, under the heading private placement. It says a company may, subject to the provisions of the section, make private placement through issue of a private placement offer letter. 42.2, the number of persons investing under a private placement offer can't exceed 50 unless that is otherwise changed in another rule. And as the judge noted in his judgment, it was changed in another rule. We don't need to look at it. The number was 200 as an operative time, but a private placement couldn't be raised more than 200 investors. If you see the explanations under section 42, if they make an offer to more than the relevant number, then what was a private placement is then deemed to be a public offer. So it sort of tips into a public offer if too many people are involved. Explanations 2 sets out the definition of a qualified institutional buyer, which is essentially a bank or other financial institution, and a private placement definition. 42.4, similarly to the explanation we just looked at, if the offer isn't in compliance with the rules, then again it becomes a public offer and has to comply with the public offer rules. Now, there are two sorts of private placements under the Act, or under the regulations. If you go back to the regulations on tab 2, and we can start on page 42. The first private placement is what's called a preferential issue, and that's at letter NN of page 42, which is issue of specified securities to any select person or group of persons on a private placement basis in accordance with Chapter 5 of the regulations. And Chapter 5 of the regulations can be seen from page 79. And there are various rules about who can make it and when it can be made, and the price at which it can be made, and certain disclosure requirements to shareholders. But there isn't, for a preferential issue, a requirement to appoint a registered merchant bank. The other form of private placement is a quip, as Lady Justice Falk mentioned. If you turn back to page 44, the first bundle of these regulations, quip, qualified institutions placement, is at the top of the page, letter TT, an issue of eligible securities by a listed issuer to qualified institutional buyers on a private placement basis. And the definition of qualified institutional buyers just in the previous page, as you can see, and maybe as would be expected. So there's the private placement, there's a general preferential allotment, if you like, and a special form of private placement, which can be made to qualified institutional buyers. The applicable rules for a quip are set out on page 87. And just to show you, section 174 on page 88, for a quip, as with the further public offer, the issuer has to appoint a registered merchant banker. There are also disclosure requirements on the quip. There's a different pricing requirement and various other rules about minimum numbers of LLTs, etc., which don't, I think, matter for present purposes. So that's further public offer, private placement in their two forms, and the last form is a rights issue. Going back again, please, to page 44. A rights issue at XX, that third of the way down, is an offer of specified securities by a listed issuer to the shareholders of the issuer as on the record date fixed for the said purpose. And there's a further set of rules relating to rights issues beginning on page 46. And for present purposes, we can go to section 69 on page 49, which has the same obligation to appoint a registered merchant banker on a rights issue. There are also disclosure requirements on a right issue on page section 70, which are broadly similar to the FPO disclosure requirements. There's an obligation to file the relevant offer letter with Securities Board. And at section 90, on page 55, and the judge makes reference to this in his judgment. The process for a rights issue is an allotment to the shareholders in full, to the extent that they want them, a sort of residual allotment to shareholders for any leftovers, and a further residual allotment to what they call renoncees. So a shareholder can renounce his entitlement in favour of a renouncee, and the renouncee can then be entitled to the shares issued on the rights issue.
I'm assuming that renouncee there includes dealing with rights that are just not taken up as well as positively renounced, because otherwise you would be left with.
I assume that must be right. There's a
So
residual.
Renouncee is in respect of any rights that aren't taken up
Aren't
for
taken up.
any reason, whether positively transferred or
I assume that's right, but yes, as you say, otherwise there would be a bit of a gap in the sequence. So that's the Indian background. If we go back to the judgment in the core bundle tab 9, page 95. Paragraph 15. So the judge became familiar, too familiar with the ins and outs of those regulations we've looked at briefly, but he noted at paragraph 15 that it's possible to raise capital via several of these methods in combination, so you can do one or others together, and you can have a preferential issue or quip that brings in new shareholders and a rights issue, which includes the previous shareholders and new shareholders, etc. And at paragraph 16, he noted, I think I showed you this earlier, but now in context, that that Cantor couldn't act as lead manager of the public offer, of the quip, of the rights issue, but it would be able to assist with any of those investments as an offshore advisor. So it wasn't that it couldn't do anything, it just couldn't do the specific matters precluded under the section. Still in the judgment now, the principal elements of the judgment, if I can show that briefly, really in 6 parts. If you go to page 109, the judge began with what he called the ordinary meaning of the words used. And he focused at paragraph 85, as needs to be focused, on the definition of financing, capital F. And the question is whether it's private or public, as he described. In 86, he identifies what the judge describes as a conventional understanding that where you have an adjective followed by 3 nouns, the adjective governs the 3 nouns unless something happens in the middle to change that. And as a result of that, he reached the provisional view at paragraph 90 that the definition of finance, the word private in the definition of finance applied to each of the 3 elements that of investment because of that conventional rule. That was, as he put it, just a provisional view subject to other things that he was going to look at. So that's the first element of his judgment, the language and what he said, the conventional view. The second element from paragraph 96 is what he describes as the contractual context, i.e. the other sections of the agreement on which there were some arguments before the judge, and there will be some argument for your lordships and ladyship. But the judge, by and large, didn't find anything of particular significance in the other language of the section. You see on page 112, he looked at clause 2, he looked at clause 5, and he looked at clause 6, and he looked at other bits and pieces, but he didn't find anything of essential significance in those matters. So that's the second section. The third section was what he called the surrounding circumstances, which begins on page 110. And this is a reference to essentially the underlying facts or the factual background in ED. And the judge noted at paragraph 110 that the bank was in financial distress. He concluded at paragraph 112 that it was obvious that a further public offer was not a possible solution, and that a further public offer only became possible because of the estate bank intervention. He then said at 113 that possibility or lack of possibility must have been discernible to Cantor. And then at paragraph 120, essentially reaches the conclusion from the surrounding circumstances, which is that the surrounding circumstances make it unlikely that the parties intended Cantor to be involved in an FPO. They are more consistent with the word private, modifying not only placement, but also offering or other sale. So the basis of the judge's reasoning was, at the time in December 2019, Yes Bank would not have been able to make a further public offer. And therefore, it's a relevant consideration on the construction of the clause, as he saw it, that what was potentially available wasn't in fact available in December. That's the background. The next point of the judgment, the fourth element, is what he describes as genesis and aim. And this was essentially from paragraph 121, essentially responding to a submission of Yes Bank advanced by way of respondent's notice for your lordships, that the genesis and aim of the agreement was essentially to provide private finance in the short term, and that this is discernible from various pieces of evidence, which we might have to look at briefly. The judge's conclusion was that the material wasn't sufficient for him to reach any conclusions on the genesis and aim, and therefore that point didn't affect the construction. And that then reaches its conclusion, gets to its conclusion in paragraph 136, which is that the original view about the language isn't displaced by anything else he's looked at. But if anything, the surrounding circumstances support that, because it was obvious that a public offering was not viable as matters stood in December 2019. And lastly, just so you have it, and relevantly also, the judge then dismissed a number of defences put forward by Yes Bank, some of which sort of appear in the respondent's notice. That's why I want to mention them here. 118, you can see the defences very briefly. 142, it was said that Cantor had to provide the relevant services which led to the investment, and that was dismissed on the basis of the agreement, clause 3b. 143, it said there was a causation requirement between Cantor's involvement and the investment. That was also dismissed. 144, it said that the agreement had run its effective course once the Reserve Bank of India intervened. So essentially things changed at that point, and that was dismissed as being inconsistent with the contract. 145 is the point about Hinduja, which we'll have to come back to, and then a termination argument. So if we can now move to the core issue of interpretation for the court, as to the meaning of those words that we've looked at in clause 1. And the starting point, as we know, it doesn't matter essentially where you start as long as you cover all the ground. But the starting point, I submit as the best starting point, is the background of fact, which is limited, as I showed you, in terms of relevant and admissible material for the court's interpretation. It's enough to note, we submit as factual background, that as the judge found, this bank was an Indian commercial bank which required external finance as a matter of urgency. Cantor was a US broker-dealer which was able to offer both its expertise and the benefit of its relationship with potential investors, and that parties engaged Cantor on that basis. So as the judge found, the arrangement was not just for the services, if you like, it was for the client book.
Sorry, it was for the
client book, the investor book. If you go back to the judgment at page 95, paragraph 16, Cantor was 3 lines down, 4 lines down. Cantor was able to offer both expertise and the benefit of his relationship with potential investors. From Yes Bank's perspective, one principal reason for engaging Cantor was the perception that it might be able to introduce and or successfully woo investors who would not otherwise be involved, in particular investors from the US. So we say that's all the relevant background you really need in terms of construction. The second part of relevant background is the Indian law position, in particular the existence of 3 types of financing. We looked at private placement, public offer, and rights issue. So there's not a binary distinction between private and public. There's a third element, which is a rights issue, which I'll come back to. But also, as we saw from the relevant bits of this section, the statute, the distinctions between private and public as a matter of Indian company law were themselves rather fine. In circumstances where what began as a private placement would tip over into a public offer if they didn't comply with the relevant regulations, for example. So it's not as if there are watertight categories between the different issuances, and one can become the other simply by a matter of compliance and non-compliance. So that's the relevant factual background. Moving on to what the judge called and continue to call the overall contractual context, i.e. the other parts of the agreement. There are two elements of the agreement we say are significant. First is that whilst Cantor was obliged to carry out the services specified in clause 2, which maybe just turn that up so that we have the argument in front of us, 169 tab 17. So whilst Cantor was obliged to carry out provide those services in clause 2, the payment obligation was triggered on the closing of any financing with investors. And the obligation, as we saw, was to pay 2% of investments by the investors listed. And the consequence of this is there's no causation requirement linking any specific work by Cantor to a financing or any particular investment. As the judge held at 139 of his judgment, not in dispute, the trigger for payment was merely the investment. And that underlines the reality we submit, as the judge held in that paragraph we just looked at, that what Yes Bank was purchasing was not just the services but the book, and agreeing to pay for investments by the client book. So that's the first part of the relevant context we submit. The payment mechanism itself is significant. The second element of relevant context from the agreement is its duration, which is clause 6, which I mentioned briefly earlier at page 171. And the way this section works is that Cantor can terminate at any time. Yes Bank can only terminate after 9 months, and after a further, and there's then a tail fee of a further 9-month period, within which any financing that is arranged will then trigger the payment obligation as well. You can see that in clause 6. So the just starting from the top, can be terminated by Cantor or by the company after 9 months by written notice, provided that Cantor will continue to be entitled to the full amount of any compensation pursuant to section 3 in the event that any of the events specified there, and that's a financing, occurs prior to the expiration of 9 months after any termination, and prior to the expiration of 9 months, any termination of Cantor's engagement hereunder, an agreement is executed by the company pursuant to which a financing is subsequently consummated. So even actually, the minimum term is potentially longer than 18 months. So it may be longer than that. But in any event, that's the term of the agreement. Now, the operative length of the agreement we submit is a significant contextual factor when coming to view the clause that we have to look at, because it stretches the period for which Yes Bank was to pay for the benefit of the investments from Cantor's client book to at least 18 months, and regardless of developments in the meantime. There's no carve-out for any development or intervention or anything else. It's an 18-month straight obligation. And this means that it's entirely wrong, we submit, to approach the question of interpretation by focusing on what was or was not likely or possible in December 2019, or in advance of state intervention sometime after December 2019, because Cantor was not being engaged to provide such financing as could be achieved in December 2019, or to provide such financing as could be achieved before state intervention. Cantor was being engaged to provide services for the period we looked at, and Yes Bank was agreeing to pay for the 18-month period we looked at, in circumstances in which it was necessarily unknown what the financial outlook would be over that 18-month period. So the failure to undertake, we submit, the process of interpretation by reference to the actual duration of the contract undermines, at least in part, the judge's approach, what the judge called the factual background. He focuses on the position of December 2019, wrongly we submit, but it also undermines respect, practically the entirety of the argument of Yes Bank, whose argument is continually focused on the position as at December 2019. And the argument that will be advanced for your lordship is only a private placement was viable in December 2019, and therefore one has to construe the words with that sort of narrow straitjacket attached to it.
And you say it must, sorry. You say it must encompass any form of transaction which was reasonably contemplated as a possibility over the term of the...
Yes, exactly. And the irony of this case is the only transaction that was actually consummated was a further public offer within the period. So yes, but that's just... That's after the event, I understand that.
That then raises the question as whether that was something which was contemplated as a reasonable possibility at the time of the agreement over its duration.
Yes, well...
And the judge seems to have found, in paragraph 105, that what actually happened was unpredictable, is the word he used.
Yeah.
Well,
so does that mean it is nevertheless, on your formulation, a realistic possibility that was contemplated at the time of the agreement?
yes, because what we submit onto the wording is that the wording is deliberately broad to include all possibilities, and there only are three possibilities available, i.e. private, public or rights issue. And the wording is sufficiently broad to encompass all three, because as at December 2019, there's no evidence to the contrary. Nobody knew or could have known what the situation would be like in that.
That assumes what you're setting out to prove. Leave aside for the moment what the wording says as a matter of interpretation of the wording. We're here looking at what the background was by way of factual matrix as to what would have been in the minds of the parties as to reasonable possibilities within contemplation at the time of the agreement.
Yes.
And you make the point, which I entirely understand, that has to be what they might contemplate over the scope of the whole agreement, not simply what they envisaged in the short term when it was executed.
Yes.
But that still leaves the point, doesn't it, that if they did not contemplate as a reasonable possibility over the term of the agreement any form of public offering, then the language has to be interpreted by reference to that understanding.
Well, there was no evidence, but certainly no finding that the parties did not, because the question essentially wasn't properly addressed, that the parties did not contemplate a further public offering as a possibility within the 18-month period.
Well, that's why I just had in mind, I picked up the language in paragraph 105, I think it is, of the judgment. It is a reference to your argument on this point.
Yes.
As allowing for one of unpredictable developments. If public intervention by the RBI was not something that was predictable, and without it, a public offering was just unrealistic.
Well, I see the argument that in a sense, it's Yes Bank's case that a public intervention was very predictable. Indeed, there's some documents that they've sought to put in through the respondent's notice from the Reserve Bank of India, specifically contemplating the possibility of intervention. So if that were the right question, was intervention by the State Bank of India within the reasonable contemplation of the parties, I think both parties would submit absolutely yes, because that's in a sense part of Yes Bank's case. But the question for your lordship, I think, is what, if it's reasonably contemplated even after that, what would then happen? But there was no finding by the judge that any form of financing was or was not in contemplation in the event of intervention by the State Bank of India.
And no findings by the judge about the intervention or the likelihood or otherwise?
I don't think he may have talked about, I can't specifically remember whether he talked about the likelihood of intervention, because that was certainly part of the, if you like, the debate at the trial as to whether or not the Reserve Bank of India were looking over the shoulder. 112, I'm grateful. All right, but he said it only became possible because of the intervention. Well, that may or may not be, well, we're not challenging that, so absolutely fine. Oh, there we are. Grateful, my friend. It must also have been obvious to Cantor that a yes bank's position continued to deteriorate if Indian regulators were likely to become involved.
Well, that's slightly different.
What paragraph's that?
That's paragraph 112.
It wasn't just the fact that the central bank was likely to be involved if the position deteriorated. It's whether it was contemplated as a realistic possibility that it would involve the very substantial funding from State Bank of India, which was what put it on a footing to be in a position to launch a public offering.
Well,
It's not quite as narrow a point as whether intervention by the Reserve Bank was contemplated, is it?
I think your Lordship is right, and I don't remember there being any exploration of, if you like, actual contemplation of what a funding might look like in the event of state bank intervention. I think that would be, I suspect, too speculative for anybody to have to deal with. But the context of the trial certainly was that intervention by the regulatory authorities was a real possibility. Say no more than that, because I think the next stage is probably going too far. I don't think, to answer your Lordship's question, we can say any more than that. But going back to the way I think your Lordship framed it, I wouldn't accept that a relevant question is, did the parties or would the parties contemplate a further public offering in the event of state bank intervention and in the event of a capitalization to make that sufficient? Because that, with respect, seems to be a rather focused and after the event analysis of what actually happened. More to what we seek to draw from the term of the agreement is that this was the factual background as I submitted was they needed capital in any event, and the agreement was for capital over an 18-month period, and that really there was no evidence, in a sense you wouldn't expect there to be evidence one way or the other as to whether particular forms of financing were or were not viable over that period. What matters is they were available under the Act over that period in circumstances in which the future was by definition unknown. And therefore, the straitjacket your Lordship sought to identify, I'd kind of rail against, is not a realistic approach to construction in the circumstance of an 18-month agreement in an unknown period of time. And the right approach to it is not by focusing on what positively was or was not included, but to ask whether over that period of time, did the parties agree positively to exclude things? And if one puts it that way, the uncertainty suggests in my submission that they wouldn't agree to exclude things because one wouldn't know what the future might hold. So can we go, please, to the operative clause itself, which, go back to page 169. And the ultimate question for the judge of the court is whether, these things can often boil down to a narrow question, private placement, offering or other sale of equity instruments means private placement, bracket, then any offering, or if you like, any other sale of equity instruments, or private placement, private offering, or other private sale of equity investments. That's essentially the dispute between the parties. And we submit, just starting with the language, that the language, on the face of it, is capable of bearing both meanings we would accept. But the more natural meaning of individually broad and inclusive words is wide rather than narrow, especially the words other sale of equity instruments, just as a matter of language on its face, we submit is broad.
Can I, just before you launch on the language, can I just ask what your submission is on this point? This is perhaps slightly unusually a definition which is introduced by reference to it being what Cantor has been advised is being contemplated by Yes Bank.
Yes.
Is it therefore part of the permissible matrix to interpretation to identify what in fact Cantor was advised as to what Yes Bank was in fact contemplating?
Look, this is a respondent's notice point that's been advanced by Yes Bank. I'll come on to that, of course, but
Sorry, I didn't want to take you out of your turn. Deal with it when you want to, if you'd rather come to it later.
we just as a little highlight, it's not admissible because it's simply a preamble. But in any event, the judge found that the judge refused to make any findings on that in any event. So I'll come back to that, but that's what we say about that.
Thank you.
But one starts with language, and we say the wording of the language itself, just those words alone, is broad rather than narrow. The other words around this clause are equally broad rather than narrow, and we say inclusive rather than exclusive. So it's one or more financings, including without limitation, in one or a series of transactions. Now, it is the case that none of those words specifically or directly affect the definition of financing, but the ways in which a financing can be achieved in multiple routes or otherwise. But again, we submit that they are broad and expansive terms and consistent, we say, with the approach that an objective reader of this agreement would take, which is that the parties are seeking to ensure that everything is caught that can be caught in circumstances in which parties don't know and can't specify exactly what will happen. They don't know whether there's going to be one financing, they don't know whether there's going to be multiple financings, they don't know whether there's going to be linked financings or otherwise. And the language we submit is consistent with that approach to this agreement, which is inclusive rather than exclusive.
But it's not any form of financing. It's equity instruments, for example. It doesn't cover bond issues.
It doesn't cover bond issues.
So it's already a subcategory of types of financing.
Yes, it's absolutely right.
And it's financing in relation to equity instruments.
Yes, it does have that.
And the in any form wording and the width of that follows is really as to the form of whatever is meant by private placement offering and other sale in relation to equity instruments. Forms of equity instruments. It covers what an equity instrument is, including the obvious example of convertible bonds.
Your Lordship is of course right that it doesn't include everything, and it has that constraint attached to it, and absolutely there's no dispute about that. Nevertheless, and maybe harking back a little bit to Your Lordship's question, which I didn't fully answer in any event, but I may keep chipping away at it. It's consistent with a position in which the parties are not able to specify in December 2019 precisely what will happen, because they don't know whether it's one, or be equity, yes, they don't know whether this equity will be a one-off, will be multiple, will be together with anything else. So even though it's within the broad category of equity, yes, they are trying to ensure that as much as possible within that broad category is covered. And I would submit, more consistent with the answer I sought to give Your Lordship, is that the parties are not agreeing to exclude. And the question is not that, rather than are they specifically agreeing to include things that they actually have in mind. So so the wording itself, we say, is on its face broad. The surrounding wording is also inclusive. And the third point in language is the use of the word private placement. Now that is a term, as I showed you, specifically used in the Companies Act, with a defined meaning in the Companies Act. And we submit that in the context of an agreement for the financing of an Indian public company, where a term is used which accords directly with the statutory term, there's a good reason. I can't say it's conclusive, but it's a good reason to give it that meaning to which it is accorded under the statute. Also, when it's clear from other parts of the agreement that, at least in some respects, the parties are engaged with Indian law concepts, as you can see from the rest of Clause 1, which deals with equip. So we submit that there is significant force in the use of the word private placement because it's a term specifically found in the Companies Act. And if that is right, if it's right to accord that with its statutory term, then that's a strong pointer we submit to Cantor's interpretation. Because if private placement is a legal term of art, then the word private isn't being used as an adjective. It's being used as part of a phrase. And therefore you shouldn't and wouldn't need to use the word private for the other things as well. So that's a matter of grammar. If it's a part of a phrase, it's not an adjective, or at least not a used adjective. And also, if private placement is used with that connotation as a term of art under Indian companies law, there's no other form of private transaction which is available under the Companies Act. It's public, private, or rights issue. So the only privates are private placements. That's the only form of private transaction under Section 42 of the Companies Act. So if private placement used in the agreement means private placement used in the Companies Act, then quite apart from my point about grammar, the phrase, we submit that the other words must mean something else. So private placement deals with all the private transactions because that covers the entirety of the grant, and therefore offering or other sale, we submit as a matter of interpretation means something that is not a private placement. And the only options are therefore rights issue or further public offer. Now, that, if you like, my first point was the point on the grammar, the phrase point. The point I've just made is often dismissed as an argument against redundancy. The argument is, well, there you are, you can double up, and it's no necessary inference that because private placement covers the grand, the others must cover something else. And obviously, we're all familiar with the principles. We're all familiar with the cases that say that's not a very great presumption in many cases. Normally in a settlement agreement, when parties are doubling up to make sure everything's covered, that's normally a situation in which the court says argument against redundancy isn't very powerful. Slightly different we submit in this case, where it's an engagement letter, where the parties are seeking to ensure that money will be paid in certain events. And there's no reason why the parties would simply double up those events. There's more reason we would submit that the parties would ensure that the relevant events are covered across the piece. And therefore the argument against redundancy, I've got to accept that the cases say it doesn't carry very much far in many situations. We submit in this case it carries me rather further than perhaps might otherwise be the case in a settlement agreement, because there would be no obvious reason for parties to include other transactions offering or other sale if they already cover the ground by private placement. Can't take that argument all the way, can't take any of these arguments all the way, but each of them we submit support the conclusion. So taken together, those wording points we submit support the wider interpretation when applied also by reference to the background facts that we saw, which was Yes Bank in need of financing and the agreement over an 18-month period. It also accords, we submit, with what might be regarded as the objective commercial bargain, where Yes Bank was paying for services and its client and Cantor's client list over the operative term of 18 months. You also asked me again the question about what was specifically in contemplation. In a sense, that isn't also really the relevant question because of the context of this agreement. Cantor were supplying the investment book. Yes Bank were buying the investment book over that period of time. From Cantor's perspective, it would only be paid if there was an investment by one or more of its investors. It was commercially irrelevant to Cantor how that investment was achieved. Public, private, rights issue, whatever. As long as there was investment by an investor, the mechanism was completely irrelevant. That may be another answer to Goshuk's question. I told you I keep coming back to it. Nobody cared what the precise form was. As long as there was a financing, Cantor would be paid. It didn't matter from Cantor's point of view what the precise detail was. Equally, we submit, as at December 2019, it wouldn't have mattered to Yes Bank what the precise form of financing was. It was buying the investment book. It didn't matter to Yes Bank whether it could get a private offering up the ground, a public offering up the ground, or anything. It just wanted the money. And therefore, from both parties' commercial bargain point of view, we submit the detail of the transaction is irrelevant. What they were selling and what they were buying was the investment. And beyond that, nothing else mattered. And what has happened in this case is that events have have occurred in 2020, the intervention, etc. And Yes Bank has sought to run the argument that matters have changed. And because of the State Bank intervention, what they earlier agreed for in December 2019 no longer applies. And that was the agreement has run its course argument, was rejected by the judge. But we submit that leaving aside what happened afterwards and looking simply at the commercial bargain in 2019, the detail that we're now arguing about, because it's relevant because of what happened, was not a matter of commercial significance to either party at the time. Not on the basis of what they bought and what they sold, as the judge found. Can I now deal with some of the points raised in the judgment, and beginning with paragraph 86, page 109. And this is the section which I showed you a little earlier, where the judge described his conventional rule of grammar, that if you have an adjective and it's followed by 3 nouns, then unless the pattern is broken, it's expected that the adjective will govern the 3 nouns. And as it's apparent in the judgment, albeit that was his provisional view, and he then sought other things to support or undermine that, ultimately he came back to that as his actual view, so it's clearly significant in the judgment. We submit shortly there's no such linguistic understanding the judge identifies. There are some phrases which carry a natural meaning, such as the judge's every Tom, Dick and Harry, which is an idiom, everyone knows what that means. And there are some phrases which carry a legal meaning, negligent act, error or omission. But it's wrong to extrapolate from that into some general rule of language. As we submitted in our skeleton, whether an adjective governs 1 noun or 3 nouns is dependent on the words used and the context in which they are used. And we've given all sorts of examples in our skeleton, which could be either way, small table, chair or lamp, all depends on the context. Red hat, gloves or coat, we can go on forever as to all the different possibilities. The answer is you don't know simply by reference to the words, you need to look at the context to see whether the adjective applies to 1 or 3. Especially so in our context, where you've got the word other. So you have, even on the judge's view, something discordant or something intervening between the original adjective and the subsequent nouns. Does that change the analysis? It may do, it may not do, but it all depends on the context. So we submit the starting point was the judge's starting point was the wrong starting point, in that there isn't a conventional rule that one adjective necessarily governs all 3. The answer is you have to look at the actual words used in the context in which it's used, especially when you have the word other in between. So that is a starting point we say is the wrong starting point. And there are 100 examples one could think of where the adjective doesn't govern the 3 nouns because the context doesn't allow it. Also note, if you go please to my friend's skeleton, page 64, tab 6, page 64 of this bundle. Paragraph 30, on this, if you like, linguistic point, Yes Bank make the point that the relevant phrase doesn't use the word public before offering or sale. And it's submitted that is significant, i.e. private placement, but it just says offering or other sale. It doesn't say or public offering or public sale. And it said that is a significant indicator of interpretation. We submit that's just wrong for at least 2 reasons. First, it rather turns the process of interpretation on its head. We don't say you need to use the word public in there, because we say the words offering or other sale is sufficiently broad. It's the defendant, Yes Bank, who seeks to interpolate the word private before those words rather than anything else. So we say we don't need to interpolate the words public. The words themselves are sufficiently broad. But also, as we saw...
But if you're right that private qualifies all 3 nouns or sets of words, then that's that's a non-point, isn't it? Doesn't matter that the word public isn't used.
It doesn't matter at all the words public, because the words themselves are sufficiently broad to include private and public, exactly. And also, as we saw from the
Even
regulation,
if they're right that offering could be any sort of offering. I mean, sorry, if you're right that offering can be any sort of offering,
yes.
then in one sense it doesn't really matter whether it's qualified by private, public, or nothing at all.
Well, that's what we say. Private placement, we know what that is, and the rest of it is sufficiently broad to cover everything.
This whole line of argument really depends upon your being right. Private placement is a term of art under Indian company law.
Well, that's one of the points, yes. I mean, that in itself probably gets me home in
There
itself.
are various ways of putting
Yes.
the point, but it comes
Yes.
back to.
But I was just trying to deal with the point that it's not an answer to say, well, there you are, they haven't used the word public, because we don't need the word public at all.
No, I understand.
So that's the, if you like, the first of the point made by the judge. If you then go back to the judgment of page 109.
Yeah.
Still on this issue of the ordinary meaning, at paragraph 89, and you can see that above all, the judge is explaining the bases on which the ordinary, what he regards as the linguistic rule applies. And he says, well, above all, therefore obviously significant, this formulation or this grammatical use was deliberately used in clause 5. So he says, well, there you are, you've used it there, therefore it should be assumed that they've used the same convention in clause 1. If you can go to clause 5, which is 17, page 171. And the relevant bit that he's talking about is Roman 2 and 3, or Roman 2 in particular. So this is a slightly curious clause. It's allowing for Cantor to have the right to have various other engagements. And one of the rights at 5.2 is to be lead financial advisor in the event of any non-domestic potential acquisition, disposition, or other extraordinary corporate transaction. And what the judge said, well, there you are, if you look at that, non-domestic is an adjective, and it must be used to qualify acquisition, disposition, or other extraordinary corporate transaction, because the domestics were already being catered for. And he said, therefore, that is an example of his rule, namely an adjective applying to all three nouns. At least one of the problems with this is if you look at Roman 3, the other entitlement is co-advisor in any domestic potential acquisition, disposition, or other extraordinary corporate transaction. So this is a prime example of how context gives you the answer, not the rule gives you the answer. Roman 2 expressly deals with non-domestic transactions, and Roman 3 expressly deals with domestic transactions. So for the reason the same adjective governs the three nouns in each case is, a distinction has been drawn between the two categories. So it's a very good example we would submit of how the context gives you the answer, and it's incorrect to say that that's the product of a rule, because it's non-domestic in one context and domestic in the other context, and therefore the adjective clearly applies to all the transactions in each category. So the judge saw that as above all as significant. We submit it's not significant at all when we realise the full context of the wording being used.
Will you come back to clause 5, Roman 1?
I'll try to come back to clause 5, Roman 1.
Thank you.
It's not an easy clause, but I will try to do that. I think yes. In fact, let's deal with it now. We've all struggled, I think, over what this actually means. It envisages the right, or the apparent right, to take on a further role of lead book running manager for any financing, capital F, lower F, involving equity securities, other than a capital F financing. And that immediately raises the question as to what is the sort of transaction which is being envisaged here. Now, the suggestion we made to the judge, and which appears to us the most, if there's any suggestion at all, which I didn't want to go into, is that it may envisage fundraising outside of India. It may envisage a sort of transaction outside of India.
At the very least, it appears to envisage some sort of equity fundraising that is not a financing
Yes,
as defined.
yes.
Whereas if I've understood your argument on clause 1, you're really saying
Any
financing
equity,
as defined includes all forms of equity finance.
any form of equity financing would fall within other sale of equity instruments if it didn't fall within the rest.
Well, this is the difficulty we have with this clause. I accept that. I mean, the difficulty. First of all, it may be referring to a non-domestic transaction, because the reference to book running manager, it may be.
Well, there may be no evidence on this, but the Indian rules you've taken us to don't necessarily all cease to apply just because an Indian company does something outside India.
Lord and Lady, I think that may be right, but then again, there's nothing in the Indian companies legislation dealing with a book running manager. It's not a concept.
That's a commercial concept.
Maybe so.
I suspect others understand.
So, I mean, that was one possibility. Another possibility we thought, I simply don't know, but the definition here is on its face more extensive, because of financing involving equity securities, as opposed to our definition, which is a sale of equity securities. Now, whether or not there's a financing which could involve equity securities, whether a derivative or some other transaction, I don't know, that doesn't involve a sale of equity securities, that would fall within that gap. If one is trying to find a gap, the words used are different, in fact, and the words involving is broader than simply sale. But there was no evidence as to what that sort of transaction might be or might not be, but that's on the face of the wording a possibility.
Sorry,
What sort of financing could it be?
Well, I don't know, for example, whether there could be a derivative financing involving securities that doesn't involve a sale, or some other. Just all I'm saying is simply on the wording, it's
But
different.
This is all
wording.
about fundraising. It really is all about fundraising. So, in a generic sense, it's a sale. There is a sale, isn't there?
Well, or whether, and I don't know
In
whether
any
this would
form.
all fall within it, whether a bond transaction might fall within it, if that's secured in some way in equity securities.
a mortgage transaction,
Yes.
essentially.
So that would be a financing transaction
With a pledge of-
involving
with a pledge of
securities, not involving a sale. So I think there are possibilities as to what it could mean. The wording is different, so there are possibilities what it could mean. The other possibility, of course, is that one views this as a clause being added without necessarily the rigour that one looks at it in the Court of Appeal as a matter of construction.
But the difficulty, well, but just taking these things in stages, just go back to your point that financing involving equity securities might be wider in the form of a transaction. You still have to give some meaning to clause 5.1 by it being a transaction in respect of which one would have a book running manager,
Yes.
which is a form of fundraising with, typically, Cantor in this example acting as the underwriter or the arranger.
Well, I see that. We haven't got a nicely packaged example that can be easily inserted into this clause as the answer to the conundrum we've just been discussing.
Do you, a slightly different point, do you say that the definition of financing in clause 1 is limited to domestic financing?
Well, it doesn't say it's limited to domestic financing, so I don't think I can say that.
No, you don't. So that's,
And in a sense, the whole point of the investors, I know there's a point on this in relation to Hinduja, but the idea of the investors, and I think the judge found, is you were looking for financing outside India, primarily clients of Cantor in the US.
Well, the investors from outside India, yes, but
Yes.
the investment itself.
Well, any investment's going to be into the company,
Yes.
so it's going to be into India. But if you're talking about non-Indian fundraising, that's essentially what this was about anyway.
Then yes, I can see that. I'm doing my best to try to see how this can be formulated in some way that makes some sort of sense. The other solution, as I say, is that it may not make very much sense. Can I show you, this doesn't take up, can I show you also, this is something in the supplemental bundle, about how this particular clause arose, if it's of help. I mean, obviously there are going to be issues about admissibility, etc., but if it's of some help, it's the let me just see. Yes, it's supplemental bundle tab 11.
Yeah.
And these are exchanges between the parties leading to the drafting of their provisions. So it's relied upon for the respondent's notice. I can't rely upon it for the construction argument because we say it's inadmissible, but just to give the court some comfort as to perhaps the futility of seeking too far down the road as to speculation is what this means. 214.
If it's not admissible as an aid to construction,
Well,
why are we looking
What's
at
it
it?
admissible for?
no, okay.
Unless you've got a case of rectification, it doesn't matter.
That's not. I don't want to open that box. So
If your submission is an agreement of this kind, may well have included boilerplate
I think that's probably as far as I can put it.
that wouldn't have any specific meaning or application. Well, that's a general point that you can make
Yeah.
without reference to the negotiations.
In that case, I'll stick there. I won't take that further. But that's right. So you're right. I've done my best to try to find a solution to 5.1, but I end up with saying there may be no solution to 5.1.
Well, you say that might be the case, but it doesn't follow from that the rest of your argument.
Yes, it doesn't exactly, because there's no interaction between those two. But what it also means, and this is why in a sense the point doesn't go anywhere, is that on any view, it couldn't be referring to a further public offer. So it couldn't be saying, or it couldn't be suggesting in 5.1 that there's a further public offer is a lower cap financing, but not an upper cap financing, which
Why do you
would be
say
the
that?
relevant, because Cantor couldn't be a book running manager on a further public offer.
That's not necessarily the same, well, I'm not sure there's evidence on this, but it's not necessarily the same thing as a registered Indian bank acting as manager. Book running manager could just mean I run a book, I put together a book.
Well, the judge found that the Cantor could only be an offshore financial advisor.
Sorry, Cantor could be.
Could only be an offshore financial
Yes,
advisor.
but okay, I'm not sure it follows that we've got any findings that means it couldn't be a whatever the parties contemplated a book running manager to be.
Well, the regulations we looked at are quite proscriptive as to who. So it talks about lead manager. It doesn't. You know, Elizabeth is right. It doesn't talk about a lead book running manager because that concept isn't anywhere in the regulations at all. So in a sense, we're fighting against something that we can't really get hold of. The judge found, just to make sure that we have that. Yes, Elizabeth is right. All he says at paragraph 16, page 95, is not registered. It therefore could not act as the lead manager of a rights issue. It would be able to assist with any of those transactions as a mere offshore advisor.
Yeah. Going back to your point, to pursue this slightly further, your point is that, fundamental point is that Cantor was selling its client book.
Yes.
How far is that from book running manager in a loose sense of let's find some investors who may be prepared to invest in any form?
Well, lead book running manager, I mean, there's no evidence and there's nothing under Indian law about this, but on its face, it suggests a actual position. Whether it's a US position, I don't know. We don't know evidence of that either. But it does suggest a position which Cantor could agree to engage with or not. So it's not simply providing its book, it's actual position. But the trouble is we don't know what that position was or where that position would be located, or what the conditions for it would be. On the judge's side, certainly the judge didn't say expressly offshore financial advisor was the only thing Cantor could ever possibly do, but he did say that that's what they were able to do under the Indian regulations, paragraph 16. But there was no evidence before him or finding that it could be a lead book running manager on a further public offer. That simply wasn't part of the, there was nothing at all about that.
Whilst we've diverted you, can I, on the same topic, just look at what functions Cantor could could perform in a public offering, a further public offering, by reference to what's described in clause 1. What it's agreed that Cantor should do is act as A, financial advisor, B, placement agent, and C, arranger.
Yes.
Now, in relation to a public offering, could Cantor act as either an arranger or a placement agent?
No.
So, if it's to cover public offerings, it must contemplate Cantor acting as a financial advisor.
Yes.
And that, in what sense is it acting as a financial advisor by providing its client book?
Well, that appears to be the terminology that parties used for that particular role. In fact, if you see...
Well, that rather that begs the question as to whether that was the role that they were envisaging. Clearly, in a private placement, it certainly could be providing financial advice, but it could also be the placement agent and the arranger. So
Yes.
the book, the client book function, as it were, comes within the second and third of those categories.
Yes.
But it can't do so for a public offering.
It can't do it, it can only be the offshore.
So
Advisor.
where does the client book come in?
The client-
in relation to those functions for a public offering.
The client book comes in the provision of the investors. In fact, one can see that in the other context of the QIP provision, which is set out in the remainder of clause 1, which refers to the fact that in a QIP, Cantor can't be a placement agent or arranger, but rather offshore financial advisor with investor referrals. So the context that they're talking about in that is the offshore financial advisor is somebody who provides investor referrals. And when the judge refers in paragraph 16 to Cantor being an offshore financial advisor for all the types of transactions we submit, he was referring to that concept of being an offshore financial advisor who provides referrals.
Well,
The Lordship is
quite
right.
close, because we've got for Equip, we've got a specific function of investor referrals.
Yes.
And that is what you're describing as the client book aspect of the benefit that Yes Bank is to achieve. But we don't have that.
We don't have it expressed, that's right.
For something that isn't a Equip, which is carved out. And financial advisor means advising the company, doesn't it?
Well, I submit that that's not what the judge had in mind when he referred to, at paragraph 16, a mere offshore advisor. Because what he is talking about in this paragraph, and one reads it as a whole, is first of all, it can be a mere offshore advisor, but he then says, be that as it may, i.e. whatever its particular role is, it was able to offer both an expertise and the benefit of its relationships with potential investors. So, taken together, we submit, what he is describing as a mere offshore advisor is somebody who can provide at least the benefit of its relationships. Your Lordship is right that looked at in English eyes, there's not much advice going on here. I see that. But the judge had in mind, we submit, that the offshore advisor role was a referral role.
Because I mean, the offshore advisor role is not limited to offshore financial advisor, but includes providing investor referrals. So it's in the clause itself, It's defined.
Well, no, it's
An offshore financial advisor, and that in such capacity, Cantor may provide investor referrals to the company.
Which suggests
So-
that the offshore financial advisor role has a wider context than merely the investor referrals.
well, it may have a wider context, but it certainly includes the investor referrals.
Yes,
Oh, sure.
but financial advisor, by contrast, in the clause, just says financial advisor.
It does say financial advisor.
It doesn't have any reference to investor referrals. I think that's the point that.
Well, no, but the judge
Needs addressing.
found that the Cantor could act as offshore advisor. So
But
the
only
judge,
in relation to equipment.
no, expressly in relation to all of them. In paragraph 16, he expressly finds he could act as a mere offshore advisor for IPO, FPO, QIP, or rights issue.
No, if we're just looking at the clause.
Oh, sorry, the clause. Sorry.
Not the judgment, the clause.
The clause.
The clause only contemplates being an offshore financial advisor in relation to equipment.
Well, it singles out offshore financial advisor in relation to QIP. It deals with financial advisor more generically in relation to the engagement as a whole. And the judge found that that Cantor could act as offshore advisor for all other transactions. So taking those together, and whilst it's another situation perhaps where the clauses don't entirely mesh in a perfect way, the financial advisor engagement we submit includes offshore financial advisor, as the judge found that Cantor could act as. And offshore financial advisor includes the provision of referrals. It may include other things as well. It may include advice of some sort, if it can be given in accordance with the regulations. But we're not concerned about advice. We're not. That's not part of the analysis. As long as it includes referrals, then Cantor would be engaged to provide those referrals through its investment book. None of that would make it, in my submission, lead book running manager. It's a different context. So that's all really I can say about clause 5.1. I think I sought my best to get to the end of it, but there we are. If we go back to the judgment, the next part of the judgment, page 107. The judge addresses the argument, which I made earlier, about private placement being a term of art under Indian law.
Yeah.
And the judge concluded that it wasn't, or it shouldn't be assumed to be a term of art under Indian law. As you say at the bottom of the page, it shouldn't be assumed to be a nod to the regulatory background because other terms are used which aren't referable to the background. And there are some terms used and some terms not used in the section. And in fact, he says at Roman 5, just pick up the point we just talked about, some examples of cases that have an established legal meaning in the US, not familiar in India. For example, lead book running manager. That's what he found for what it's worth. Anyway, the judge didn't accept that it was an Indian company law term. Instead, he concluded it was a broader phrase in use. If you go to page 110, paragraph 94.1. So I consider it unrealistic to proceed on the basis that private placement is being treated as an Indian term of art, rather as a phrase in general worldwide use amongst professional people with a financial background. So you're seeking to take it out of the Indian context and say it's a general phrase. Now, my first mention is wrong about that. It's appropriate to apply the Indian context for an Indian financing. That's a natural start.
I thought you said that clause 1 isn't confined to an Indian financing.
When I say an Indian financing under the Indian Companies Act.
But I thought you earlier said you accepted that clause 1 wasn't confined to domestic financings.
Sorry, yes, to be clear, I accepted it wasn't confined to domestic financing, but it is necessarily confined to a financing which the company can do under the Indian Companies Act. it couldn't extend to a financing outside the Companies Act because the company doesn't have power to do it. So, Your Lordship is right. I can't say that the definition is limited to a domestic Indian financing, but I can say, and we submit it must be right, that the definition must be limited to a financing permitted under the Indian Companies Act, whether that's domestic or abroad or not.
Yes.
So that's why we say once one realises that the definition must be limited to a financing permitted under the Indian Companies Act, where you have a term used under the Indian Companies Act, the natural interpretation is that the term is used in accordance with the Indian Companies Act. That's why I put that.
And why is it not capitalised in the same way as quip is?
Well, it's not capitalised in the Companies Act either, but I mean, it's not. Yes, of course, it isn't
No,
capitalised.
but you see the point. If it
Of
was
course it
being
is.
used as a term of art, one might have expected it to be capitalised in the same way as quip is.
It could be. The second submission that even if that's not right and it's not an Indian term of art, on the judge's interpretation, it is still a term of art. i.e. it's a term of art, a phrase used in general worldwide use amongst professional people of financial background. And if that's right, which is the, if you like, the bare minimum, the point still holds good. Because even if it's not an Indian term of art, it's still a term of art. And if it's a term of art, it's used as a phrase, i.e. private placement is a phrase. And if it's being used as a phrase, it's not being used as an adjective to govern other nouns. So the point still arises, even if it's at the Indian context, as long as it's a term of art, one approaches the interpretation of that clause we submit as a definition in itself, private placement, and then looks at the other words. One doesn't need to use the word private to define the other words when the word private is being used as part of, as the judge said, a phrase. So the point still holds good even outside the Indian regulatory context, if, as the judge said, it's a term of art. All these points are simply points one would put into the mix to see where one gets the answer. But in my submission, the word private placement, whether under the Indian Act or otherwise, is significant. Moving on, if we can, to page 115. There is the question the judge raised and discussed at various points about how one fits a rights issue into the definition. Because the background here, of course, is that there are three forms of financing: a public offer, a private offer, and a rights issue. On Cantor's definition, private placement means private placement, offering another sale mean everything else. On Yes Bank's interpretation and on the judge's interpretation, private governs everything, so everything must be private. So private placement, private offer, and private sale. The question throughout the trial and still now is how that one fits a rights issue into that interpretation if it were right. Because a rights issue is neither public nor private.
I'm probably missing something, but why is it so important to work out whether
Maybe for this reason.
our
if I
rights
can.
issue is covered?
We submit it's important for this reason. The judge expressly found, I'm going back to my points earlier on, that the parties either did include or didn't exclude a rights issue as a possible venue, as a possible venture. That's paragraph 117. So even before the agreement was written, on the judge's findings, a rights issue was actually in contemplation or not excluded from contemplation as part of this agreement.
Actually, in contemplation or not excluded, those are two different things.
Well, he says,
He said
117.
it was in contemplation.
It needs to read 118 as well, if we're going to make that.
Yeah.
What paragraph?
117, page 115, he says it's not clear that the parties actually had in their minds at the time the possibility of a preferential issue in combination with a rights issue, but I do not consider that they could have ruled it out. By contrast, they could have ruled out an FPO and in fact appeared to have done so. And
he's making a specific point about a combination of a preferential issue
Well, he
and a
is.
rights issue, not you're trying to use this, I think, to make it broader.
Not necessarily. All I'm seeking to advance is this, that it is a legitimate question to ask, to compare the two interpretations with a rights issue. this being something which at the very least the parties hadn't ruled out.
I'm not, because at 118 he says they cannot have had in mind using Cantor to help with a pure rights issue.
He's talking about, yes, the distinction is a pure rights issue on its own, and 117 a rights issue in combination with something else.
Right. So at the moment, the argument you're addressing, as I understood it, is a pure rights issue within or outside the scope of the clause as a financing.
No, we can run the argument is it as part of a combination, because of course the financing could allow things in combination. It's the same point.
Yes.
Is a rights issue, let's run with the argument as part of a private placement within the private definition or within the broader
If
definition.
it's coupled with something else, then it's the something else that matters rather than the rights issue, isn't
Well,
it? Because it's the something else that is or isn't going to trigger it being a financing, and therefore
How does that follow? Under the Companies Act, there were 3 forms of financing. This was one of them, and they were different. There was a public, private, and rights issue.
Okay, can I make a much more basic point, which probably I try to explain why I don't completely follow this. As you said earlier, or as you say, this was about attracting new investment through Cantor's client book.
Yes.
A rights issue goes to the existing shareholders, whoever they are. So that's not obviously what is going to generate fees for the sort of transaction that's going to generate fees for Cantor under this agreement. I can see in conjunction with a rights issue, which may be why the judge was focusing on it, you could do a preferential issue where you bring those investors in, or you could bring them in effectively as underwriters to the rights issue. But that's somewhat different. The focus of the agreement, I think you've made this point, is getting investment from Cantor's clients. On the whole, this is new sources of funds, not existing
Well,
shareholders.
No. In theory, yes, it's right that a rights issue is outside investors. As I showed you, one of the roots of a right issue involves offerings to renoncees.
Yes, that's my point. They're the I've used the term underwriters, but that's how it works.
And there was, in fact, the judge described in his judgment, before the further public offer, in fact, before the intervention, Tilden Park made an offer which was a preferential issue in combination with a rights issue. That's at paragraph 69 of his judgment. So I agree, it's not, a rights issue is not in and of itself the most obvious way by which Cantor would obtain fees, but it was certainly a potential way in which Cantor could obtain fees through some other thing, as combined or otherwise.
And would it be a way of attracting new money, even if not combined with anything else, in that after the announcement of a rights issue, but before taking up a right, Cantor could, for example, persuade the Hinduja group to buy a lot of shares in the market with a view to then putting in the additional capital as the holders of the rights at the moment that the rights issue took effect.
Well, the evidence certainly from Cantor's witness was that everything was on the table. All sorts of possibilities were out there. You just had to find the right one that worked. So yes, a rights issue on its own, in principle, could have been achieved through Cantor's efforts, albeit that in the event, what was...
Well, I was making a slightly narrow point, which was it may be that a rights issue will attract new capital.
It may do, yes. Certainly you can't exclude it. And at the stage...
Sorry, new capital from
investors.
From investors who are not shareholders at the time that it's announced.
Yes. Yeah. But so it's a possible route of funds. It still raises the question, if so, how does one, even combined with a private placement, how does one achieve that definition by reference to the 2 competing versions? Now, the judge concluded that a rights issue could, even by itself, be regarded as a private placement under Indian law. That's paragraph 94, page 111.
Is he making a comment there about the Indian law definition?
Well,
Because I'm not.
I don't think so.
111 Roman 2, he offers the view that a rights issue could fall within the contractual definition of private placement.
Okay, but he's not talking about the Companies Act definition though.
No, he's saying
It's
we.
wider than what he says is it could, the words private placement could be given a wider meaning in context than merely the definition under the Companies Act. That's the point
Yes.
he's making. So it could include a rights issue on that basis.
It could include a rights issue. We say he was wrong about that in circumstances in which the Companies Act sets out the different forms of financing, and a rights issue isn't a private placement. And the reason he gives for his conclusion at the bottom is that a right, you can see about 5 lines from Roman 2 bottom, a rights issue is a way of offering placing new equity not offered to the public, only to a closed private category of people. So he's saying it looks a bit private because it's only offered to shareholders. Respect that doesn't really take us very far. A private placement was limited to 200 investors under the Companies Act. There was a limit of 200. This was a public company. I think 40% of its shareholdings were retail. It had thousands of investors. So you can't equate a rights issue with a private placement because it's got a limited number of investors. They're entirely different concepts. So a standalone rights issue, there's nothing to suggest somehow that could fall within the definition of private placement. The judge's alternative analysis at Roman 3 is that if it's coupled with a private placement, it can be termed a private placement. But and with respect to Lord Justice Popplewell's point, there's no reason why that's the case either. There are different transactions. The agreement contemplates different transactions being possible. There's nothing in the Companies Act or the agreement that says if you combine it, it turns into something, let alone what that is. And there's no reason to think that a private placement plus a rights issue equals a private placement. Why wouldn't it equal a rights issue? There's no logic to the addition of the two together. If that were right, it proves too much, because you could then say, what if you have a private placement and a public offer combined? Maybe unlikely, but who knows? What would that then become? And if that would become a private placement, because private placement somehow governs everything else, then why are you excluding a public offer at all? So there isn't an answer as to how you get it as an independent answer. Going back a long way around to my ladyship's question, if it's a single rights issue, there's no answer to it's not right to say it can count as a private placement.
Let's just assume then, for the sake of argument, that the judge is ruling that it's a rights issue. Just then, where does that take you?
It means that you cannot define private placement offer or other sale as private placement, private offer or other private sale, because a rights issue would not then fit within that definition.
Yes, but that may just mean a rights issue is not covered
It's not
by
covered.
this letter.
Well, the judge certainly contemplated that it was covered,
Well,
and
He may have
he's
made it
sort
right or
of,
wrong.
I'm not sure I'm seeing a clear decision on that.
the evidence before the judge in terms of exchanged evidence was that Yes Bank contemplated a rights issue at that stage as well. So if you can go to this is not inadmissible, this bit. If you go to the supplemental bundle,
Yeah.
page 244, which is tab 13. I'm going right back to maybe my Lord Justice's question about what was in contemplation. This is it's an email, but
I'm so sorry, which page are we at?
page 244. It's an email at the top from Cantor. At the bottom sets out a public statement made by Yes Bank in the press. And the public statement was made on the 13th of December, so it's before the agreement was signed. And you can see at the bottom of the page, last paragraph, the bank remains on course to raise capital through a preferential allotment. Said in a statement, the bank shall also consider approval to raise capital through multiple other modes, viz. quip, rights, etc., in order to have the flexibility to tap multiple options for raising capital.
Okay, as to admissibility, this is extract from a quoting from a press release, is it?
It's a quote from a press release, which is part of the, so it's a public statement by Yes Bank,
Yes, which is obviously known to
Cantor.
Cantor, so it more clearly within the factual matrix.
Yes, this is, yes. So what is within the factual matrix is that they're considering multiple other modes of financing, including quit rights, etc., in order to have flexibility. So this is before the agreement. It's a matter of flexibility. As I said earlier, in accordance with what one would expect, commercial parties would be interested to do. So your ladyship is right. My argument doesn't get anywhere if the answer is, well, that means a rights issue is excluded. But the argument is put in the premise that a rights issue is included, not least because it was actually contemplated by Yes Bank in advance of the agreement. The judge appears to have assumed it was within. He sought to argue why it could get within. And if it is within, as we submit it is within, because there's no reason to exclude it, we submit it all. It simply doesn't work with Malone Friend's argument. It simply cannot be reconciled with this construction. And therefore the construction must be wider than limited to private. So that's why, sorry for another very long way around to the answer, we say it's a relevant factor. Now, can I go back to Malone Friend's skeleton, core bundle, tab 6, page 66. Paragraph 38, this is about the rights issue point. And just one aside from this, we asked Yes Bank several times during the trial to state whether their case was a rights issue was included or not. Frankly, we never had an answer to that because it's a difficult question. There we are. First point to note about this is complete disconnect from the commercial purpose of the engagement letter, which is quite obviously for Cantor to find new shareholders, not to approach existing shareholders. This doesn't engage with my construction argument, but I've just referred to that because of the reference to the alleged purpose of the agreement. I don't disagree with that purpose, to find new shareholders, and that's consistent with what I submitted earlier in terms of the commercial bargain between the parties. But I just mention it now to flag that we get some different purposes later on in support of different arguments, which shows the danger of that sort of argument. So that's what we say about the rights issue. If we go back to the judgment, tab 17, the core bundle.
Paragraph.
No, sorry, I got the wrong up. So if we go back to the, sorry, completely wrong, tab 9, page 113. Is the judge's findings about the judge's finding about clause 6 of the agreement. And as we had a discussion earlier today, we do submit that clause 6 is important because of the duration of the agreement and therefore the focus of the argument which is then run. We sought to rely upon clause 6. The judge found no assistance in clause 6 because he said, as you see in paragraph 105, second half, the fact that clause 6 provides the engagement letter could not be terminated till August 2020 does not mean that Cantor was being given until then to provide services under the engagement letter. I do not regard clause 6 as having any bearing on the overall nature of the appointment. And we submit again, it's just wrong about that. The fact that they couldn't terminate it until August 2020 does mean that Cantor was being given until August 2020 to provide the services. Indeed, under the terms of the agreement, was obliged to do so. So it's the judge unfortunately didn't give effect to the clause. those are the last aspect I think to mention in the judge's reasoning. If we go to the surrounding circumstances, which are page 101, tab 9. Where the judge held that it wasn't obvious, or it was obvious that a FPO was not viable in December 2019. And I think I've covered most of the ground on that. We submit that's the wrong question in terms of an agreement over 18 months, but and therefore the viability in terms of the period was not something the judge addressed. Essentially, that's all I want to say about the judgment. Can I now address the respondent's notice points?
Can I just, I'm sorry to keep diverting you, but can I just articulate something else that's going through my mind? You've referred a number of times to what's permitted under Indian law, the three categories.
Yeah.
That is, as I read section 23, those are the categories in which a public company may issue securities. So that covers issuing new equity. But is clause 1 confined to issuing new equity? Suppose, for example, that Cantor persuaded the individual group or some other group simply to purchase the shares at market value and then to provide very substantial shareholder loans to the company and to inject capital in that way. Would that come within the scope of financing in clause 1 as involving other sale of equity instruments in any form, including without limitation, etc., etc.?
Let me just understand the concept. What's purchased from existing shareholders?
Existing shareholders, no new equity. Purchases from existing shareholders, but on terms that it's agreed, it's going to inject a huge amount of capital by way of shareholder loan.
Well,
I might have thought that would fulfill entirely what you say was the purpose of Cantor's involvement.
well,
And I think it fits with what you say is the width of other sale of equity instruments in any form, etc., etc., etc.
more yes. The abiding starting point, as you know, we say, is that in December 2019, everything was on the table. This was a bank in desperate need of financing, and it didn't matter how it got it, but it needed it. And it engaged Cantor to provide investors to try to do that. Now, on that basis, one approaches this construction we submit on a generous rather than a narrow approach. And if the transaction does involve sale of equity instruments, however so done, then I think the answer is it would include your Lordship's example.
Yes. And it may be that Mr. Taylor would say the same on his interpretation because it's a private sale. But if that be right, then that does mean, doesn't it, that we're not looking at clause 1 simply through the eyes of forms of issue of new securities as permitted under Indian law. We're not looking at only 3 categories of investment that are contemplated, i.e. private placement, rights issue, and public.
Lord, yes, and does this go to my argument against redundancy, I suppose, that, well, there you are, you may have found something that isn't a private placement, but is nevertheless a sale that could be called a private sale. Well,
it's perhaps a more general point, because I think the thrust of your argument at various stages is we need to look at clause 1 through the Indian law eyes of what kinds of procedure are permitted
yes.
for purposes of issuing new securities.
Yes.
But if the financing which is covered by clause 1 is not limited to issue of new securities, then that may not be the perspective through which
Well,
we should be looking at.
Your Lordship may be right that there may be another perspective on top, but I'm not sure it changes the argument, because it's certainly maybe the argument requires more limitation, in that insofar as the definition refers to an issue of securities, it must fall within the Indian Companies Law Act, with the possibility that the definition could include something even beyond that, outside the Indian Companies Law Act. But I don't perceive that assists in or takes it very far in the interpretation of what the meaning is. I can see that there may be something, you're right to say that I've proceeded on the basis that everything must be under the Act. Your Lordship is right that there may be something theoretically outside the Act, but nevertheless, if it's an issue, it must be within the Act.
Well, it may have a bearing, for example, on whether private placement is used as a term of art in relation to issue of new securities under Indian law, or whether the example that I've just given would count as a private placement as a matter of general language.
It may do, but then it would still be a term of art. So it's the same point as such.
It wouldn't be used as a term of art, it would simply be describing the placement, i.e. sale of securities to a private individual,
Well,
coupled with an undertaking to make a shareholder loan.
well, yeah. I mean, I think the trouble is
I'm not
you do get a
suggesting,
bit
I'm not
drawn.
suggesting that it on its own, it militates definitely in favour or against your interpretation. I'm just suggesting that it seems to be the substratum for a number of your
Well, we do say it's important.
submissions, and I was just exploring whether that was that's all.
Can I add another possibility? Was instruments convertible into preferred or common equity seems to contemplate a convertible bond issue.
Well, a bond, but something that is convertible into equity.
Yes.
Yes,
but-
but I'm just to build on Lord's point. You've taken us to section 23, but I'm not sure that necessarily covers a convertible bond issue or a bond issue with warrants. There are all sorts of fundraisings with equity elements to them, and I'm not sure we've got any decision as to the extent to which they're within section 23.
Well, there are, and I don't propose to take you to it, but there are various provisions in those rules we looked at that deal with the situation of convertible securities. So it is still covered within. So that's a pretty random answer, but there are other references within these regulations.
Because convertible bonds typically will envisage down the line the issue of new securities on conversion. Is that
Yes,
right?
and I'm fairly sure that even in the definition, but I may not be able to get it on my feet, in the Companies Act, there are references to convertible securities, but I don't want to be committed to that, but maybe I can find that online. But can I just go back to my Lord Justice Popplewell's point? I suppose that the danger with being drawn into that one is speculating. Your Lordship's example of a sale from an existing shareholder coupled with an agreement to lend money. I suppose it begs the question as whether that would be a private placement or whether it would be an other sale, for example, or something else. It could still be a private placement, could still be accompanied that private placement, and your Lordship's transaction could be something else. So, in a sense, the danger of all of this in a quite typically drafted agreement is we can follow all sorts of roads down the line, and they don't necessarily lead to much elucidation, unfortunately. Anyway, can I? So I need to finish. So can I deal with the respondent's notice points? The respondent's notice is at tab 4 of the core bundle, and the first point, which I think is the main point advanced, is what they call the genesis and aim of the contract, and it harks to something my Lord Justice Popplewell raised earlier. And the submission is that the judge's findings of the surrounding circumstances didn't go far enough, and that he ought to have made specific factual findings, that it was contemplated and advised by Yes Bank to Cantor that Cantor was being advised, being instructed to raise urgent private finance. So it's a much more specific argument being put forward. And it's then said that was also the genesis and aim of the agreement. And the argument essentially stems from, as my lord pointed out, the opening words of paragraph 1, clause 1 of the agreement on page 169, which is, we have been advised by the company that it contemplates one or more financings, etc. And the argument is, well, there you are, that opens up an examination of what was advised by Yes Bank to Cantor, and whatever was advised ought to limit the definition of financing. And the problems with that, first of all, that introduces an inadmissible investigation because it seeks to interpret the agreement by reference to what was said between the parties about the scope of the agreement. Such matters would be inadmissible on conventional principles, clearly, and therefore it could only become admissible if this clause were construed in such a way as to render the inadmissible admissible and to introduce a investigation into what was said about the agreement before the agreement was actually signed.
That's classic territory of inadmissible pre-contractual negotiations, isn't it?
Yes. Well, it is undoubtedly, as a matter of principle, inadmissible. It said, well, look at this term, that makes it admissible because it says something about contemplating or advised.
That's a bootstrap's argument.
Well, I don't want to spend all that long about this, but we say it's
Well, I think the argument against you is the way this is drafted is that a financing is what we have been advised by the company that it is contemplating.
Well, that's put against it. We say as a matter of construction, this is simply preamble rather than operative term. So as a construction of that clause, it would be right to construe it as, if you like, polite preamble, not right to construe it as something which would be very significant, i.e. to render the inadmissible admissible, because that would be the
preamble
argument.
that contains the critical definition.
Well, it
can't-
starts the
you can't just
preamble and
ignore
goes
it.
on to the definition.
Which bits do you say should be ignored as preamble?
They've been advised. So we've been advised by the company that it contemplates. It is simply preamble to what the actual definition is.
So if it had simply said the company contemplates one or more financing, etc., then you'd say none of this is
Exactly the same.
even begins to be admissible.
Because one can't, because that then introduces an examination.
You have to define what the company contemplated by reference to what's set out in the agreement,
Yes, exactly.
subject to rectification.
So whatever was actually contemplated beforehand is then subject to the construction of the agreement. What you can't do is construe the agreement by reference to what either somebody had in his head, contemplated, or by reference to what somebody might have said before the agreement was signed, because then you're in classic inadmissible territory.
I'm not sure why you say, if the form of the agreement is, we are contemplating X, and you'll get paid if X happens. In deciding what X means, why do you not look at what is being contemplated? Because the agreement itself defines X by reference to what is contemplated. Now, I can see that that may give rise to difficulties if you're looking at the contemplation of only one of the parties. But that's not this case. We're looking at what has been discussed between the parties as contemplated.
Look,
And I have some difficulty myself in seeing why that is inadmissible
well,
in defining what X means, because X in the agreement is itself defined by reference to what has been discussed as contemplated.
well, I think I'd put it this way, that I don't say that such an investigation could never work. Ultimately, it's a matter of construction of the agreement as to what the agreement means. What I do say is that it would be a very unusual construction to arrive at the Lordship contemplated, because it essentially runs against all normal principles of contractual interpretation. It would, on its face, introduce into the question of interpretation that which is normally, as a matter of law, inadmissible. Now, so that's why I say I'm not saying that it would be impossible for a party to construe it, to reach an agreement which reverses the law, ultimately what it is. But it would require, I might submit, some quite strong.
possibility is that what was in contemplation as discussed between the parties is actually part of the overall contract. In other words, that the letter is not a totality of the agreement, unless there's an entire agreement clause.
There is an entire agreement.
There is an entire
There is.
agreement, so that answers that one, isn't it?
I may again be missing something, but if something was factually contemplated, before that, let's assume that before any discussions or negotiations happened, Yes Bank had certain things in contemplation, and those were communicated or became known to Cantor. Is that not part of the factual matrix?
No.
What stops it being?
Can I show you then?
I mean, this is not what the agreement means, it's just what was actually in contemplation.
What is what the agreement means, because it's being used to define the definition of financing. So it's being said the definition of financing is constrained by what was contemplated and advised. That's the context of the argument. Now, just to show you, can I go to Schofield and Smith, which is tab Authorities Bundle 1, tab 6, page 122.
Sorry, what?
Authorities Bundle 1, tab 6, page 122. Now, this was a case involving a settlement agreement. A customer sued the bank, I think Barclays Bank, on a LIBOR case and entered into a settlement agreement. And the settlement agreement covered claims against all the parties and their affiliates. Some of the parties then sought to sue their administrators. And the administrators said, we are protected by the settlement agreement because we're an affiliate of the company, and therefore we're included. And the argument on construction was that there was a mutual understanding between the parties to the settlement agreement that the administrators would not be included in the agreement. So it wasn't even something that was contemplated. It wasn't even something that was advised. It said there's a mutual understanding that the scope of this agreement does not include the administrators. And that was, if you can see that, if you go to 131, there's a passage 22 about factual background and the exclusionary rule at 24 and 25. In fact, we can probably just take it to the summary. If you 32, the argument, Mr. Davis argued that Barclays did more than merely deny liability for the conduct of the administrators. It also told Mr. Schofield it was not prepared to settle any claim against the administrators. It was thus, sorry, paragraph 32, page 134.
Yeah.
So, 4 lines down, it was Mr. Davis submitted common ground between the parties, this is by way of oral discussion, between the parties to the settlement agreement that claims against the administrators were not within the scope of the dispute. So, what was said is we agreed beforehand that the scope of the dispute would not include those parties. And that was all rejected as inadmissible. 136, paragraph 38, Lord Justice Newey. Evidence as to what Mr. Schofield was told by representatives of Barclays some months before the claim was issued can't possibly be significant. As can be seen from Merthyr, South Wales, it is not permissible to rely on either what a particular party said during pre-contractual negotiations or communications which are capable of showing the parties reached a consensus on a particular point for the purpose of drawing inferences about what the contract should be understood to mean. That is exactly what Rhino partly intending to do. So, in answer to my Lady Justice Falk's question, the starting point as a matter of law is you cannot rely upon pre-contractual discussions or even mutual understandings in support of an argument as to the meaning of a contract. You get that from the contract itself. Now, going back to the argument has to be is that legal position is excluded or is changed by reference to these opening words. So say, well, that may be the law normally, but because this clause is drafted in the way it is, you can include what was contemplated or advised because of the wording here. And we submit, I don't think I can go as far as say that that could never be done, but it's a very unusual thing to do in a commercial contract, to introduce the inadmissible as admissible. And it would require, we submit very clear words to do that, and these are, we would submit, not sufficiently clear for that purpose. So that's why we would say this is an inadmissible adventure. But beyond that, in a sense, it doesn't really matter, because the argument was put before the judge, and the judge did not accept the factual premise. The judge concluded, as is accepted in my learned friend's skeleton argument. If you go to page 73, paragraph 67 to 66, the judge dealt with this, page 73, paragraph 66, dealt with this, they're addressed together, that's the genesis point, essentially the same point being run, because of the overlap in evidence. In short, the judge held he could not determine either what Yes Bank contemplated and advised Cantor about the financing or what the genesis name of the agreement was. So the judge, having heard the evidence, concluded that he couldn't make any findings about what was contemplated or what was advised. So all of this argument kind of runs away unless Yes Bank can challenge the judge's factual findings on the factual findings appeal test, namely that no reasonable judge could have reached that conclusion. And that, with all due respect, as we submit, hopeless. The argument is put at 67, submitted the judge ought to have found that the financing contemplated and advised was urgent private financing in the parlous financial circumstances in which Yes Bank was operated to avoid intervention by the RBI. That's the argument that's being put, and we submit that the court can't sensibly make that finding. It's a burden that can't be discharged on appeal. In brief, first, to the extent that there were discussions at all between Cantor and Yes Bank before the agreement, they were between the principals, Mr. Gill and Mr. Jane, they're referred to in the judgment. But as the judge noted, neither of them gave evidence as to what they either contemplated or discussed. Mr. Gill had left Yes Bank, and Mr. James, unfortunately, no longer with us. So neither gave evidence. There was no documentary record of their discussions. None of the witnesses who did give evidence was party to the discussions, or was even able to give second-hand evidence of what they were told about the discussions. So in terms of an evidential trawl, it really is, frankly, nothing at all. Essentially, Yes Bank was asking the judge to speculate as to what might have been said between these two parties, and there was no evidence of what was said at all, and it simply can't be said the judge was wrong to fail to make the finding that Yes Bank sought to make. In addition, this argument and so much of Yes Bank's argument proceeds on the wrong basis of contract, which is the point I made already, because it's focused on December 2019, not the 18-month purchase contract. So it's the wrong question. So far as the evidence is concerned, Yes Bank relied on a collection, a sort of ragbag collection of documents, which are referred to in at various points in the skeleton. If you look at page 68, there are some documents, but those are, and I won't spend now time dealing with them, also hopeless. None of them was authored by Mr. Gill or Mr. Jane anyway. None of them contains evidence or purports to record what they said in any discussions they had. Some of them didn't even pass the line at all between the parties. Some of them were internal to Cantor, some of them were internal to Yes Bank. And none of them could properly be relied upon as admissible evidence in support of the case which is being advanced. So I don't have time to deal with all of them in detail, and no doubt reply if need be, but the idea that these documents could of themselves or could demonstrate that the judge was wrong to refuse to find that there was something contemplated or advised between these parties is, we submit, an impossible burden. that's respondent's notice 1 and 2. So report 2, the same point is put on the so-called the genesis and aim of the contract. That's just another way of describing the subjective intention of the parties. Although I would show you, please, page 78 of the Mumbai skeleton, and paragraph 81 in support of the genesis and aim argument. And you'll see, objectively, the commercial purpose of the agreement was to appoint Cantor to raise urgent private finance in the parlous financial circumstances. It was certainly not the commercial purpose of the agreement to appoint Cantor to raise finance for an FPO after invention by RBI. Just on that, first of all, that purpose is not the same purpose that I showed you earlier. The purpose they showed earlier for a different argument was to bring in investors. This is a completely different purpose which is being identified. Secondly, that's not the objective purpose at all. The objective purpose comes from the agreement itself. If the agreement is for an 18-month operative term, then the objective purpose is not to raise urgent private finance before RBI intervention. It's simply impossible to reconcile with the agreement. So to the extent that goes beyond the contemplated and advised point, that equally doesn't get them anywhere home. There are some more points on the respondent's notice. If we go back, please, to, we can pick it up at the skeleton, page 69. It said at paragraph 51 that clause 1 of the agreement makes express reference to a quip, but doesn't refer to an FPO. And you'll also recollect that it's got the carve out at the bottom in relation to a quip, doesn't refer to an FPO. It was said, well, legally, and maybe this is part of the discussion we had earlier, legally Cantor could not be a placement agent, for example, in relation to an FPO. There was a carve out enabling them to be an offshore advisor on a quip, and therefore it couldn't be followed, they couldn't be instructed to engage in something which they were legally unable to engage in. The judge addressed that by reference to the terms of the agreement itself, and he noted at paragraph 2 of the agreement, page 169, that the services to be provided were limited to those which were permissible under Indian law. So he said it doesn't matter that the clause 1 is on its face wider than would otherwise be permitted, because by reference to clause 2, and there's another clause in the annex, they were only ever being engaged to provide services which they were legally able to provide. And therefore, insofar as they weren't legally able to provide the services, you reverted back to the services which they could provide in the offshore financial advisor as described by the judge. So the reference to the quip exception doesn't explain or doesn't justify the exclusion of FPOs from the agreement. Then you're simply left with the argument, well, they mention a quip, but they don't mention FPO, which is just a matter of how you drafted the agreement. The judge concluded, in relation to that point, that it may well be that a private transaction was more in their mind, or was more immediately in their mind, and that's why they drafted it that way. That's all speculation, who knows, but it doesn't justify the exclusion of an FPO simply by the inclusion of a quip. So that's that respondent's notice. Clause, if you then go to 68 of the, well, actually, we don't need to go to the skeleton. If you go to the annex, which is page 175, clause C of the annex makes reference to a private placement memorandum. As you'll see, its company represents and warrants all information made available by the company contained in any private placement memorandum or contained in any filing or other document will be true and correct. And it said, well, there you are, they make reference to private placing memorandum, don't make reference to prospectus, and therefore that shows that a further public offering wasn't contemplated. 2 points of that: private placement memorandum isn't a term of art in the rules, but as the judge noted, this clause is wide enough to go beyond private transactions in any event, because at Roman 3, it refers to any filing by the company with any government or regulatory agency or commission. And under the rules which I showed you at the outset, there were various rules for filing with government bodies, for a further public offering, a rights issue, and indeed a quip. and therefore that could only in fact be a reference to one of those transactions rather than a private placement memorandum. So the judge said you can't read into this either an exclusion of an FPO simply because a prospectus isn't directly referred to because it's included in the subparagraph.
Sorry, you're saying there would be a filing on a QIP and an FPO, would there?
There would be a filing on a QIP and an FPO and a rights issue. So that's that one. The next one is the footnote on page 184. This is a footnote to the schedule, and you see it doesn't have any names in it at this point. And a footnote 2 refers to a QIP in the event that a preferential allotment is pursued, may revise Schedule 1 at such time in order to reflect the more limited scope of permitted outreach. The judge didn't find any significance in this, just so your lordships have the context. When the footnote was included, there was nothing in the schedule, so it didn't actually mean anything. And when something was in the schedule, which is page 189, it was excluded, deleted. So it didn't actually have any operative effect one way or the other in the original agreement or the supplemental agreement. And you can't, in our submission, work back from whatever said in this footnote into an operative effect on the definition of financing.
Well, that's why I asked you at the outset whether you accepted that this was binding at the time that it was entered into in December, because whatever clause 1 means, it must have meant the same, unless specifically changed, both in December and after the amendment. So if it falls to be construed by reference to what's in this document in December,
It does.
then it contemplates that the investors are going to be qualified, even though they haven't been named, by what's in footnote 2. And the fact that it's then removed from the amendment when they're identified doesn't quite meet the point, does it?
Well, I can see that. I think that's a fair point of respect. I can see that. The difficulty, of course, is that it's very difficult to understand even what this footnote means. As I showed you earlier, you may not remember, the private placement has a limit of 200 investors. The QIP is unlimited. It just has to be to a qualified institutional buyer. On the face of this footnote, Schedule 1 includes referrals to be made in connection with a QIP. In the event a preferential allotment is pursued, may revise Schedule 1 at such time to reflect the more limited scope of permitted outreach. It appears to us that's the wrong way around, if it means anything. So what you can get out of this is we submit difficult.
Why do you say limited? Because the preferential allotment is the one with the limit of 200.
Yes, exactly. The preferential allotment has a limited.
It's the right way around.
The right way around?
It's the right way around.
Okay, it's the right way around.
Well, it depends whether you mean limited in terms of numbers or limited in terms of the nature of
Nature of the
the
scope of the.
investor.
Well, maybe that's a bad point.
Preferential allotments are less limited in terms of the scope of who the investors might be. Which I thought that was the point you were making.
I'm not maybe right. But in any event, we submit that this all falls into the same bracket, if it means anything, as the judge's conclusion, which is that they probably had this more in mind at the time. And they may well have been drafting because they had that more in mind at the time. But that doesn't mean that the agreement as drafted and properly construed doesn't include everything that was out there as something that could be done. So all of these points essentially go to the same issue. The fact that they refer to a QIP doesn't mean, it does not follow that a further public offering is excluded. You have
It goes a
to
bit further than that, doesn't it? If on its face, footnote 2 assumes that the investors are going to be those who qualify for a QIP, those institutional investors, or in the circumstances in which a preferential allotment is pursued, then a wider range of investors who might make an investment in a preferential allotment. But it does contemplate, doesn't it, that the only people who are going to be listed as investors are those who can potentially, will potentially participate in either a QIP or a preferential allotment, i.e. a private form
Well,
placement?
well, no, I mean, Schedule 1 includes, not is limited to. So it's dealing with this possibility, whatever the possibility is, and maybe I had it the wrong way around, as between a quip and a preferential allotment. But it's not dealing with anything beyond that. So it's not saying this is the limit of Schedule 1. It's simply saying that for this particular purpose, it includes these persons. So it's not possible, we submit, to construe this in a way which argues back in terms of the construction, because it's not of that nature. And the last point is the Hinduja point, which is I think a reasonably narrow point, which is there were 3 investors that on Cantor's books. 2 of them, no issue in terms of the specific point. The Hinduja group it was, as I showed you, in the schedule. And if you go to the schedule on page 189, Hinduja group mentioned, and the footnote to the schedule by this stage includes all affiliated entities and investment funds of the parties included on this schedule. Before just go back to what my Lord Justice Popplewell's point, in relation to that footnote, the fact that the agreement was operative as at December 2019 and meant something by reference to the footnote is one matter, but one is obviously construing the agreement as amended, that operative agreement. By that stage, this footnote had gone. So when they actually identify the individual investors, there's no limit or indication or relevant work back to any of them. So even as operative in December 2019, as far as the footnote is concerned, it's not operative anymore in terms of this agreement we are now construing.
May raise a question as to why the footnote is deleted. I mean, are these, for example, all people who would qualify as institutional investors for a quip?
Well, I don't think that was explored in the evidence.
schedule.
But also, I thought the judge recorded that it was common ground that the meaning of financing hadn't changed as a result of the amendment.
He did record that as common ground, but insofar as the footnote is said to be operative.
Okay.
Hinduja schedule includes the affiliates, and therefore that's why the Cantor say they should be included. Hinduja investor was an affiliate, albeit an Indian company investor, and Yes Bank rely upon 178, not 178.
175.
175, yes, thank you. Letter A, investor means any investor that's not a person resident in India in terms of applicable Indian foreign investment related laws as set forth in Schedule 1 here too. And the judge concluded, well, insofar as that said anything, at least on that point in the definition of, at least so far as Hinduja is or isn't an investor, the point was superseded by the actual schedule and the footnote to the schedule. And we submit he was right about that. So well, that's where that's subject to anything else. That's where I get to on our appeal.
Can I just raise 2 points? Maybe you want to come back to them after shorter German, which arise on page 178, clause I of Annex A.
Yes.
The second of them is on the Hinduja point and is
Sorry, I didn't get. So which clause?
clause I,
Clause I, yes.
Page 178.
page 178, and is on the Hinduja point.
Yes.
In the last sentence at the very end, it indicates that Cantor shan't be required to provide any services, etc., etc., etc. Last sentence, last line, or any financing with an investor resident in India, and that isn't amended.
Yes.
How does that affect the Hinduja point?
Well, you say it isn't amended.
Well, that's in there. That still has to be read with Schedule 1 in the amendment. That's still part of the agreement. You referred us to the part in clause A, which expressly cross-referenced itself to
Yes.
as set forth in the schedule, and I understand that point. And the judge's point was, well, insofar as that treats it as a person not resident in India, that's been superseded by the schedule to which it cross-refers. But the last phrase in clause I hasn't been amended or superseded.
Well, it hasn't, but what that last sentence deals with is the exclusion of the obligation to act as an issue in issue management. So all they're saying is that Cantor isn't obliged to do something that would constitute institute management in those circumstances. So it doesn't tell you anything about our transaction where we're not concerned with issue management at all. So the last bit is simply in the context of the issue management role, because no doubt under the regulations they couldn't act as in issue management in respect of investors resident in India. So it's not a broader definition about the engagement. It's a specific carve out in relation to that particular role.
And then the other point, you may want to come back to this after the short adjournment, it relates to the second sentence and is perhaps more important in terms of the scope of what amounts to financing. And this is concerned, the whole clause is really concerned with what Cantor is not obliged to do. And the second sentence covers willingness to arrange any private placement or other exempt offering of the company's securities or otherwise affect the financing. And it's said to be subject to the ability to provide the services and will affect such advisory transaction.
Yes.
I don't think advisory transaction is defined anywhere, is it? I couldn't find it. But the point, whichever way it points, may be that that is intended to cover anything that, any of the activities that are contemplated as activities which Cantor is going to undertake. And they're defined by reference to any private placement or other exempt offering of company securities. And that might give some guidance as to what is meant by the financing. It's a slightly different expression.
Well, all right, I think I can maybe try to deal with that if I can. I mean, obviously, it also includes otherwise affect the financing. So it's difficult to read down the definition by reference to what precedes it, because the financing is still the broader term referring to all the things that can be done, and that's subject to the argument we have. So the fact that there's different wording used beforehand doesn't, in my submission, affect the definition of financing, because that stands aside. The exempt offering of a company securities, I can only at least postulate by reference to other parts of the agreement, is that there are references also to the US position here. And there appear to be references to exempt under US regulations. Let me just see if I can find at least one of those. If you look at page 177, that is a reference in H4. It refers to financing to fail to qualify for an exemption from the registration requirements of the federal securities laws of the US. So it looks as if, and this is what appears to be, that in addition to the Indian company law substratum of this agreement, and perhaps it might be expected, or perhaps as part of a boilerplate, who knows, this agreement also took into account the need for exempt offerings under US legislation. Therefore, when one goes back to that wording, which may be not, again, entirely precise offering, when they refer to other exempt offering of company securities, given that reference, and I think there are others which I can maybe pick up if need be.
Well, there's reference in K to the obligation to ensure that they complied with all, not only insider trading, but also other securities laws of the United States and
Yes.
India.
Yeah. So it looks as if there was a definition of financing, but whatever happened, there had to be an exempt offering under the US legislation. So it looks as if that's what they're referring to.
So then if we take that out of the equation, we're left with the activity being arranging any private placement or otherwise affect the financing. I think your point is that it doesn't have to affect the financing, however wide it is, because there doesn't have to be any causative effect,
Yes.
and in a FPO it wouldn't.
Well, it could, and indeed, the judge, there was evidence from one of the investors, Tilden Park, and the judge says in his judgment, he said he only invested because of Cantor. So there was an argument about causation. We said there's no causation requirement. If there were, it's satisfied. But so there's still a causative link, even if you're the offshore financial advisor.
Right, but take a case in which there is no causative link.
Yes.
How do you get an entitlement?
We get
By
the
reference to an activity which comes within the words any private placement or otherwise affecting the financing.
well, we get the entitlement from clause 3b, which
Well, I
is
understand that, but,
as the judge found.
the starting point would appear to be that the scope of this, which limits the obligation to undertake these activities, is that it's limiting it by reference to all the activities which might give rise to an entitlement to the fee, isn't it?
Well, what it's doing is again, look at the context, it's carving out from Cantor's obligation. I mean, the operative part of this clause, or the direction of this clause, is to make sure that whatever Cantor is agreeing to is not agreeing to doing things that are illegal.
Or that
The operative,
it's subject to Cantor's ability to provide the services.
yes.
So
So,
without.
and therefore, this is essentially notwithstanding bit of the clause. So all the agreement to do what they've agreed to do is subject to, the important part is subject to the Indian law requirement. It would be wrong, we would submit to,
That's my point. The first half of the clause is everything we've agreed to do,
well,
and that's why it may cast some light on what it is that forms the
agreed to
scope
do.
of
it
the
may cast some
agreement.
light, it may cast some light. I would submit that you don't get very much light from wording such as this when the operative part is something different. And essentially this is just describing the background when we know what they've agreed to do anyway, because it's set out in the agreement earlier. And therefore it would be wrong, we would suggest, to limit the definition by reference to that clause, which is really directed to a different point. It's not focused on defining the scope of the obligation. It's focused on making sure what isn't part of the obligation. So, I think I've gone 3 minutes over my allotted time.
2 o'clock then, please.
Court rise, if able.